Thank you for joining me today. I want to talk about negotiating sentencing in a DUI, meetings with the Crown, resolution discussions, judicial pretrials, and how I approach this. And I think it's best for me to give examples. But the first thing is, when you represent a client on impaired driving, we do a lot of those type of cases. First and foremost, you hope that you have a potentially winning case. You get the case, you get to review the disclosure of the client, receive their version of events, and after I review that disclosure, meet with the client, I know the strengths and weaknesses of the Crown case. So let's pretend, to use a few examples, that I got a half decent defense here. I got, at least a 50% chance of winning this case, if not higher. Now I'm in a position to go to the Crown and try and massage and get a careless driving offer potentially, right? So, because the Crown might recognize I have a good case. So we started our discussions. I might have multiple meetings with the Crown to convince them of this. But sometimes I don't want to give away the farm. If it's a defense that is kind of hidden that the Crown could fix, because sometimes the police can fix their error. That's an important point. I'm talking about sometimes you don't want to give away your defense. Sometimes it's very obvious, of course, that the Crown's going to recognize it. But so these negotiations go on, and the good thing that's going on in the province right now with impaired driving is I find increasingly so, especially after COVID, if the Crown recognizes that we have a good solid defense for impaired driving, they're often offering us careless driving in pretty much every county with rare exceptions in the province. So that's a good thing because it's, these are cases that the defense could win. We're not using up court time. The Crown's getting some degree of punishment. The defendant's avoiding a criminal record. Careless driving is still serious, but it's under the Highway Traffic Act. You get your 6 points, or I guess no points if there's a driving suspension. Sometimes we'll put an interlock on with careless. So that's a great result. Now, other situations, let's look at another example. So I've got an impaired driving. It's a woman. This is not a client, I'm just making up a hypothetical. I'm not going to talk about clients of mine. You can imagine I've done all of these fact patterns over the course of 33 years, though we've represented probably over 2,000 cases, and at least, if not 2,500. 401, very bad driving, very bad accident, high readings. That, unfortunately, even for a first-time offender, can and should attract a jail term. That's pretty much the range now, maybe a significant jail term even on a first offender. But there's more to it. Let's say now I'm meeting with the Crown. The Crown's very upset about this. Well, hold it now. This woman's husband just died. They're under stress, anxiety. They've been going through turmoil. They develop a bit of a drinking problem. We've got them in rehab now. They're doing better and they're on the mend. Presents a different light because there's the offense, which is very aggravated, and there's the offender. We've got to present the offender to the best light. In that scenario, I may be able to convince the Crown to join me for a higher fine to avoid the inevitable jail term if we just went in front of a judge and tried to explain this all. Because you always want to try and get the Crown to join you in a joint submission. See, a joint submission is when you can agree on sentence, because then a judge, they don't have to go along with that, but pretty much in Canada, unless it offends the administration of justice, a judge is going to go along with a joint submission. See, on that case, without a joint submission, it'd be very risky. Some judges might be sympathetic if they're liberal or neutral. A conservative judge might not care. So there's a lot of negotiation and working discussions with the Crown, getting your client into rehabilitation, counseling, and explaining things to the Crown in the best possible light. For strong cases, we're trying to convince the Crown to withdraw the charge without maybe giving away every one of our secret defenses. And for other cases, we're still trying to minimize the fine as much as possible. And of course, minimizing the driving suspension. Bear in mind, on a first-time impaired driving, you're facing 1 to 3 years. It's discretionary. That 401 case, for example, I mean, some Crowns might argue that should be at least a 2-year driving suspension, if not higher, and you want to try and get it down to 1 year. So there's a lot that goes on behind the scenes in criminal law, discussions with the Crown, plea negotiations. And sometimes you'll want to get these things approved as well, depending on the case. Like the scenario I gave you about the woman on the 401, the hypothetical, what I would do after the joint submission with the Crown is I would want to get a judicial pretrial where I can talk to a judge and a Crown, the judge is going to do the plea, behind closed doors to get that judge to approve the plea, because I don't want to go, I want to know what's going to happen so I can explain it to the client. And it's much easier to explain things behind closed doors than it is in open court. If you have a judge hear that this woman's driving all over the 401 and blew 250, they might go crazy depending on how conservative. So it's very important to have these discussions, and you have to know your judge, you have to know your crown, what to say, when to say it, how to present it, and timing's of the essence. It takes a lot of years in this business, and I'll tell you, negotiations in criminal law are much like negotiations in life. It's an art form. There's no science to it. It's learned behavior where you have to do the right thing at the right time to get the right result. And I'll tell you, I'll repeat that. You got to know your judge and know your crown. So that's, and we do, our office does for sure. So anyway, it's been a great day of videos, guys, and we'll see you next time. Thanks for joining our YouTube channel per usual. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.